Hello friends, good evening.
Good evening, sir.
Good evening, sir.
Yeah, good evening. Shall we start? Yes, how's the Josh?
Hi, sir.
Yes, excellent. Yeah, so yes, I understand after auditing, you would have been a little drained out, right? It's okay. At the end of the day, yes, 3 exams are done. Nothing to worry how it has gone. If it has gone reasonably good or reasonably decent, excellent. Keep the same momentum going so that you can score well in group 1, right? If some of the papers have not gone well also, nothing to worry. Next paper is an opportunity to compensate, right? We have to maximize. We can maximize in this paper 4. As I have said in classes also, this is the paper that we can easily score 60. Easy to score 60 because of MCQs that we have, right? So with this, we'll start with the session on R2R. Again, we are nothing technical here. We are not discussing anything related to the subject. Even if you ask questions, I don't know the answer. Okay, so what we have to do, it's kind of a trailer that the next 1.5 days is the real picture, the real film. This is the trailer on what we have to do. You'll get a understanding of what we have to do, what are the topics that we have to approach in the next 1.5 days, which is crucial, right? So what should we do? We have to just, again, a reminder, we have to study hard, no matter if it seems impossible, no matter if it takes time, no matter if you have to be up all night. What we have to remember, the feeling of success is the best thing in the entire world, right? So how the session will go on, for the first 10 minutes, generic about the exam. Since we have already written 3 exams, we know most of it. Again, a reminder, because they are important. The next, after that, the next 30 minutes, very important. That gives us the insight on what we have to do in the next 1.5 days, right? And the last 10 minutes, yes, a general discussion, a concluding part. Again, no subject specific questions. So we'll start the general discussion. Now, this is the last exam of group 1. So give your best in this. Now, as we all know, since we have already written auditing paper, it has 2 parts. Question paper has 2 parts, MCQs and descriptive. MCQs for 30 marks and descriptive for 70 marks. MCQs, again, do we have to have separate preparation for MCQs? The answer is no. No separate preparation for MCQs. Why? Because again, in MCQs, they are asking concept-based questions only, right? So here we have to be conceptually more clear. So we have to just focus on our concepts. We have to just revise whatever we have learned. So no separate preparation required. However, when you're answering MCQ questions, read the question carefully. Read the question carefully, preferably twice, right? We have 30 marks, 30 questions. So it's completely all right. Even if you take more time and read the question twice, it's completely all right. But don't make mistakes in answering, right? So yes, we will read the question carefully, but filling the OMR correctly is also very important. Right, you would have already answered the questions in MCQs. OMR sheet, you will be given an OMR sheet wherein you have to fill in the answers, right? So we have shared the correct option. So there, even though you know the correct answer, while shading in that hot seat, you might go wrong. So be very careful. The question number, the option that you are shading. So fill in the OMRs carefully, and for God's sake, don't skip any MCQs. No negative marking here. So you have to answer all 30 MCQs. Even if you don't know the answer, inky pinky ponky. Okay, now coming to descriptive part, the 70 marks. Here, read the question carefully, right? It's not that we have to understand the requirement of the question, right? It's not that just because audit committee has been mentioned in the question, they're not asking the applicability. It might be they're asking the composition of the audit committee or the role and functions of the audit committee, right? So read the question carefully. Why? To understand what is the requirement, and write the best question first. In case of descriptive, because the examiner, he'll be evaluating the first question that you answer. So first impression will be the best impression. So write the best question first, which you know. Having said that, how should we approach the exams? The first 1 hour of the examination is very crucial, right? We can consider it as a power play. We have to maximize our marks there itself, right? So what we should do, we should start with MCQs itself. MCQs out of 30, with the level of preparation that we have, 25 easily we can get. Okay, worst come worst case, I'm telling 20. Even if we get 20, so 30 MCQs, 30 marks, 30 questions, you can definitely answer in 30 minutes. Right? 30 minutes, you can definitely answer. The next 30 minutes, come to the descriptive part. One question of 14 marks, which you know the best. Take 30 minutes and answer 14 marks. It's okay. But best answer, it should be the best answer. So that even if you get 10 marks out of that 14, 20 plus 10, in the first 1 hour, you have 30 marks in your pocket. So that completely removes the pressure that you have, right? Balance 2 hours, you have to get the minimum of 10 marks. So that completely removes the pressure, and you can maximize the marks in the next 2 hours also. So that is how our approach should be. So write the best question first, and in spite of that, there might be some question of you're not understanding anything of it. You're not getting from where they are asking it, so you're not able to answer. So at that point, nothing to worry. Ignore that question as of now. Write all those questions you know. Come back to the question later. At the end, look for some hint in the question. There might be some hint in the question that helps you to understand from which chapter, from which topic that particular question is being asked, right? So that might help you to remember the answers. And more importantly, format of answering in case of descriptive, right? The structure that we have learned, the provisions of the law and facts of the case, analysis and conclusion. Yes, facts of the case and provisions of the law can be interchanged, but suggested to write provisions of the law first, because at the end of the day, facts of the case is nothing but what you have there in the question, right? So if you start with what is there in the question, that might not look good for the evaluator. So if you start with the provisions of the law, if you write the section numbers first, that adds value to your answer. So preferably start with provisions of the law. Is that clear? Right? So this is how we need to approach. And yes, I said provisions of the law, will be writing the section numbers, but don't quote wrong sections. Even if you do not know the section numbers, it's okay, as per the provisions of the Companies Act. That's more than enough. So don't quote the wrong sections, and you can still use charts, right? While bringing out certain applicabilities, penalties, etc. You can definitely use charts wherever possible. And whenever they ask differences, preferably use tables. Okay, have table, two columns, and bring out the differences. And focus on writing qualitative answers than quantitative. We are not here to fill up the papers, right? Even for 5-mark question, if we write 5 points in 5 sentences, if those 5 points are perfect, you'll get full 5 marks. So it's the qualitative answers that are important, not the quantity. And utilize the reading time, that 15 minutes time that we get. Very, very crucial. At that point, I don't suggest to look into MCQ questions, because MCQ questions, anyhow, we have 30 minutes time once you are allowed to write, right? So go through the descriptive question paper, decide on which are the questions that you are writing, decide on the order in which you are writing. And even after that, if you get a time in that 15 minutes, start with the first question you are answering. There in your mind itself, go with start with the flow in which you want to write, what are the points that you want to cover, etc. So by the time that 15 minutes is covered, if whatever answers that are there in your mind, those questions, come to the last page of the answer paper, jot down those points. Question number 1, these are the points that I have to cover. Question number 2, these are the points that I have to cover, so that it helps you while writing the answers. While writing the answers, 1, you will not miss out on the points. Point number 2, you need not remember, you need not bring out those points at that point, because all the points are already jotted on. You have to just frame sentences and write the answer. So that becomes easy for you for the flow of the answers, right? So these are the things that we can do in those 15 minutes time. And yes, already covered. You can use the last page for rough use if required, and frame the answers in your mind before writing. The structure of the answer I'm talking about, right? So what should come first? What are the points that we have to cover, and what is the order in which you need to write the answers? And simple language, but appropriate words. We need not use hyphen words in the exam. Simple, whatever the language that we know, but certain keywords have to be used, right? Certain keywords, the key terms that we have learned, those terms we have to use. And legible handwriting, the evaluator have to understand what you have written. Maintain normal speed. Unlike FR, this paper will not be lengthy. It will definitely not be lengthy. So you can, with your normal speed, you can easily cover the entire paper in that allotted 3 hours. So maintain normal speed. I'm not telling to be complacent, not too slow, the normal speed that you have, right? The normal speed will have multiple advantages. One, you need not focus on your handwriting. In your normal speed, you will have the same handwriting, the normal handwriting that you have. And second, the flow of thoughts that you will have, it will be better when you are maintaining the normal speed. So this helps you to perform better, right? These are the points, some of the points. Again, we have some more. Write correct question numbers, the way I told in shading the MCQs, the OMR sheet. So even in the examination, in descriptive answers also write correct question number. If you get time, attempt extra question also at the end, right? If they are evaluating the best answers, in that, not the first answer, best answers, in that case, if there are some grace marks awarded to that extra question that you have attempted, so you'll get that marks, right? So attempt that extra question, even if you do not know the answer. Just write the question number and write one sentence. Just copy paste the question, whatever is there, right? So that helps. And normally paper for corporate and economic laws will not be standard. However, even if it is standard, evaluation will be easy. So we need not worry about, right? And we should not stop writing until 5 p.m. the allotted 3 hours. Why? We have spent months, years together for what? For those 3 hours, right? So utilize those 3 hours for the fullest extent. So sit there, write whatever you know, scribble whatever you know. Who knows, that might be the correct answer, right? So please don't get up till 5 p.m. And as I said earlier, first hour is very crucial, the power play. You have to maximize whatever extent possible, and take all stationaries, including calculator. For law, why calculator? It is required, right? There are certain questions. In winding up, we have discussed there are certain problems, practical problems, 185, 186 limits, right? They could be simple calculations, but that simple calculations become complex in exams. So please carry calculators as well. Clear? Okay. Now, these are some general topics, general points that we have to discuss. Now, coming to the subject specific. Now, corporate and economic laws, we all know, divided into two parts, company law and economic laws, that's the other laws. In company law, these are the clusters that we can have, groups that we can have, directors, meeting, and KMP. The first 3 chapters, 25 to 30 marks, very standard and time consuming. Right? Standard and time consuming. Inspection, inquiry, investigation, prevention of operation mismanagement, and compromise arrangement, amalgamation, just a procedural aspects. So we have to just spend some time to that. So to understand the procedure, easily we can score 10-15 marks there. And NCLT, special codes, foreign company, miscellaneous provisions. In miscellaneous provisions, we have removal of name, dormant company, punishment for fraud, registered valuers, and Nidhi company. Simple and easy, 20 marks. Winding up, it's easy but lengthy topic. 5 marks will be asked from that particular chapter. And drafting resolutions of late is not being asked. However, even if it is asked, it's easy. We can easily score that. And in economic laws, IBC and PMLA, very important chapters. You cannot miss these 2 chapters because 15 to 20 marks from these 2 chapters itself. IBC and PMLA. PMLA, very small topic, but 8 to 10 marks. SEBI, LODR, and FCRA, 10 to 15 marks. They're easy, but they're time consuming. Okay, time consuming, specifically those SEBI and LODR provisions. FCRA to some extent is reasonable, but time consuming. So, but 10 to 15 marks still important. FEMA and arbitration conciliation, it is time consuming, and even in the examination point of view, 5 to 10 marks can be asked from those topics. So accordingly, based on the importance given, we have to plan our preparation. Having said that, all topics are important, nothing can be skipped. Right? These are just the level of importance that I'm talking about. I'm not telling to skip any topic. Okay. Now, individually in each chapter, what are the points, what are the topics that we have to look into, right? First, we'll start. That's why I said it's like a trailer, what all we have to cover in the next 1.5 days. First chapter, appointment and qualification of directors, section 149 to 172, 2 hours you can spend. Minimum and maximum number of directors for public company, private company, OPC, right? Maximum directors is by passing special resolution, altering articles, etc. There are many provisions there. Directorships, DIN procedure, surrender of DIN, cancellation of DIN, etc. And rotation and retirement, very important provisions, reappointment of retiring director, Section 160 procedure, appointment, deposit of 1 lakh, etc. Then 4 different types of directors under 161: additional director, casual vacancy director, alternate director, nominee director, women director. Applicability can be asked, vacancy can be asked with regard to women director, small shareholder director procedure can be asked, procedure of appointment, independent director, very important, they can ask the applicability and the qualification of independent directors, and separate resolution for appointment of directors, individual directors, separate resolution has to be passed, disqualification 164, vacation 167, resignation 168, removal 169. So in case of removal, procedure, resignation 168 also procedure, disqualification and vacation, certain specific points there, those disqualification points are important. Next, second chapter, meetings of the board and its powers, section 173 and 190 to 195. Again, you can spend 2 hours here. Frequency of board meeting, 4 meetings in a calendar year, 120 days, right? And video conferencing related, rule 3, the procedure that they have to follow, the conditions to be satisfied, quorum of the meeting, circular resolution, conditions to be satisfied to be considered as circular resolution, and powers of the board, very important, 179 subsection 3. We have many points there. Those resolutions have to be passed in the board meeting only. And section 180, restrictions on the powers, 4 points have to be passed in general meeting, special resolution. Then contribution to charitable fund, political parties, NDF, National Defense Fund, certain points, political party has to be in board meeting only, etc. That we have to focus on. Then 185 and 186, loan to directors 185, LGSI procedures 186. In 185, we have complete prohibition, we have allowed subject to certain conditions, and we have exemption. And 186 procedure, we have limits. What if within the limit, exceeding the limit, right? So those procedures have to be looked into. Related party transactions, 188, the procedure to be followed, audit committee approval, board meeting approval, general meeting approval, in what cases we have to consider. Disclosure of interest, 184, 2 categories, general disclosure, specific disclosure, 184.1 and 184.2. Then committees, 177 and 178, audit committee, nomination remuneration committee, stakeholders relationship committee, and vigil mechanism. Applicability, constitution, the main points that they can cover there. And the directors, non-cash transaction, section 192. So it is prohibited, but rather certain exceptions are also there. We have to cover. Okay, these are the points that we have to cover. The third chapter, appointment and remuneration of managerial personnel, section 196 to 205, 1 hour we can spend. So totally these 3 chapters, 5 hours we can spend. It is worth, because we get 25 to 30 marks here, right? So 5 hours is worth. At the end of the day, the next, we are saying 1.5 days, but in those 1.5 days, we'll get effectively 18 to 20 hours of preparation, right? So in those 18 to 20 hours, we have to manage somehow. So 5 hours we can keep to these 3 chapters. What are there in the third chapter? Managing director, full-time director, manager definitions, their tenure of appointment, and their 196 has additional disqualification, mode of appointment, schedule 5 appointment, central government approval. Schedule 5 has, part 1 has conditions for appointment. Then managerial remuneration, profit-making companies, inadequate profit cases based on effective capital, limits which is given in part 2, right, based on effective capital, both for managerial person and other directors. Both limits are important. And compensation for loss of office, there we have discussed for managerial personnel, for other directors. Then appointment of KMP and secretarial audit. Secretarial audit, only applicability. Nothing more than that can be asked. Applicability, however, can be asked in the exams. Next, fourth chapter, inspection, inquiry, and investigation. Easy chapter, but you can still spend 1 hour because it is worth it. Okay, there we have first inspection, routes of inspection under 206. We have different routes there, ROC, central government, and similarly in investigation also we have different types of investigation, 210, 212, 213, right? There 210 again has different parts for different routes. So there, look into the procedure, powers of the inspectors, power to seize books, power to investigate related company, follow-up action that can be taken by the central government, and investigation into ownership, a separate set of investigation. 216, restriction on securities, freezing of assets, etc., time limit up to which it can be freezed, and protection to employees, and legal advisors and bankers, immunity given to them. These are some of the points that have to be looked into. Next chapter, oppression and mismanagement, prevention of oppression and mismanagement. 241 to 246, 45 minutes can be spent here. Who can apply for oppression and mismanagement? What are the orders that NCLT can pass? And we have one more here, class action suit. Who can apply for class action suit? Against whom it can be applied? And what are the orders NCLT can pass? Okay, the next one, compromise arrangement and amalgamation, section 230 to 240, again 45 minutes. Here we have procedure. This is purely procedure. First, we have compromise and arrangement, procedure for C&A, 10 points. Those 10 points, if we remember, that helps us in merger and amalgamation also. First one, 232, normal merger, same. The procedure is the same, but both the companies have to follow the procedure. That's all, right? In mergers and amalgamation, we have 6 methods. One, normal, 232. 233 is fast track. Who can go with fast track mergers? That applicability is there. Then 234, foreign company. Nothing is there. A normal provision will apply for foreign company amalgamation also. Then 235, transfer of shares. 236, purchase of minority. The difference we need to understand. Transfer of shares, you acquire 90%, then tribunal will allow 10%. Minority shares, you have already acquired 90%, then you can acquire the balance 10%. Central government, 237, amalgamation. Then NCLT and NCLAT, small chapter, 15 minutes, you can complete this. 407 to 434. NCLT orders, appeal against NCLT or NCLAT, what are the time limits? And NCLAT can take the appeals of which orders of NCLT, NFRA, and in Competition Act, correct? Yes. Then companies incorporated outside India, section 379 to 393, 30 minutes. Some important concepts are there. First one is definition of foreign company, 242. Then electronic mode, what constitutes electronic mode? There are various points there. And what are annual returns to be filed by a company, a foreign company, filing of documents, right? Change of information, and various documents that we have discussed, and prospectus related provisions have to be looked into. Specifically, this foreign company definition, very important, whether it is a foreign company or not, the basic definition, right? That's very important. Next one. Compounding of offenses, adjudication and special court, simple chapter, 30 minutes, different types of offenses, compoundable offense, non-compoundable offense. What's the difference basically, right? And non-cognizable. Normally, all offenses under Companies Act are non-cognizable except fraud related. 212 investigation, SFIO investigation cases. And then we have mediation and conciliation panel and special courts, general topics. Next one, miscellaneous provisions and topics. Yes, even though it says miscellaneous provisions, it has various subtopics. So we can spend 1 hour 15 minutes there. Removal of name, very important discussion. The procedure, we have 2. One by the company, second by ROC, right? So both methods. So procedure is very important. Restriction on application, certain companies cannot apply. And appeal to NCLT, the time limit within which appeal has to be made after 3 years, after 20 years. We have points there. And then next topic is punishment for fraud. Just the penalty that we have to remember. There are 2 different set of penalties depending upon the quantum of the fraud that has happened. And general penalty, section 450, where there is no penalty prescribed in any provisions of the law, the Companies Act. Then the next topic is dormant company. In case of dormant company, what are the companies which can be classified as dormant company? Significant accounting transactions. There are 4 or 5 lists of significant accounting transactions, which are not significant accounting transactions rather. Then the procedure to apply for dormant company, procedure to apply for active company status. Both are important. Ineligibility. Certain companies are ineligible to get the dormant company status. Reapply for active company, I have already discussed. Then registered valuer, who can act as registered valuer? Eligibility and qualifications. So there are certain rules with regard to registered valuers of eligibility and qualification, which are important. Next, Nidhi companies. Normally, in descriptive questions, Nidhi company may not be asked, but in MCQs, they can ask about Nidhi companies, right? So they are important, and specifically this exam focus more on Nidhi companies. There are lots of amendment happened in Nidhi companies. So focus on Nidhi companies a little bit. Incorporation related, we have certain points. Minimum number of members in case of Nidhi company, net owned funds, minimum amount, term deposits related, encumbered, unencumbered, etc. Share capital, they cannot issue preference shares, only equity shares. Then dividend, and the maximum 25% is the maximum dividend. Deposits, the interest rate on deposits, interest rate on loan, maximum amount of loan that they can give, right? And directors, what are the returns that they have to file? Even audit provisions also that also have to be discussed. Again, amendments have happened in Nidhi companies, so focus. Next one, winding up. In case of winding up, again, it's a lot to discuss there, lot to remember there. So 1 hour 15 minutes you can spend. Types of winding up: compulsory and voluntary winding up. Compulsory winding up by tribunal is only covered under Companies Act. Voluntary is under IBC. Right? When can a company be wound up? There are certain lists, special resolution has been passed, etc. There are various lists. 5 years not filing annual returns, dormant company being 5 years, etc. Who can file the petition? Company, contributories, ROC. There are various people who can file the petition. Filing of statement of affairs, audited accounts, winding up and advisory committee, when it will be constituted, who will constitute it, and what are the composition, the composition of the committee, stay of suits, content of liquidation report, set off of the shareholders, if they have to receive and pay set off, is it possible, share calls, who has the power to make the call, arrest of person out leaving India, and order of priority of payment. Very, very important practical question can be asked. Order of priority of payment. In winding up, we have one set of order. In IBC, we have one set of order. Both are very, very important. Preferential creditors, overriding preferential creditors. Again, these are important. Why? For order of priority of payment. Right. So focus on those. And fraudulent preference, transfer not in good faith. The time limit is important. The time period that are covered, fraudulent preference and transfer not in good faith. Last one, drafting resolutions. If you have time, you can spend 10 to 15 minutes, just go through the points that you have to keep in mind. In CAPS material itself, we have one page, one set of points that are there that have to be kept in mind for drafting resolutions in case it is asked in the exams. Okay, this is about company law. Next, coming to the economic laws part, first chapter that we have is SEBI and LODR regulations 2015. You can spend 1 hour 30 minutes here, 1.5 hours comfortably you can spend. Constitution of SEBI, right? Who are the members of SEBI and their qualification, their time limits, their tenure, etc. Removal of members, powers and functions, penalties. Penalties are important. We have discussed. Normally we can remember the general penalty, but certain specific has the specific penalties like insider trading, etc. They have separate penalties prescribed, right? So that is how we have to remember. Adjudication and appeals, the order of appellate authorities, Securities Appellate Tribunal. From that you go to the Supreme Court, etc. Then insider trading, price sensitive information. Who is an insider? What are insider trading provisions, or what is insider trading? Basically, it is prohibited. Then coming to LODR. Here, composition of the board. Now, here what we can do is we can compare it with the company law provisions so that it will be easy for us to remember. Instead of reading this separately, compare it with what we have learned in Companies Act. And committees also. Those 3 committees, audit committee, nomination remuneration committee, and stakeholders relationship committee, same, the composition of the committee, meetings, etc. Compare it with what we have learned. We have a table in the material, right? So compare it with what we have learned in the Companies Act, it becomes easy. Risk management committee is only there in LODR. It's not there in the Companies Act. And these committees are important because in the recently there was an amendment which was applicable to the previous exams also, but it might be, since it was not much asked in the previous exam, can be asked in this exam. Committees are related, LODR provisions. Then disclosures. There are certain disclosures that they have to make. Related party transactions related, proceeds of IPO, a quarterly deviation statement, annual deviation statement that they have to submit, and business responsibility statement, change in directors, etc. They have to disclose. CEO, CFO certification, quarterly and annual compliances. There are some changes that has happened in the very recently. So those quarterly annual compliances that they have to meet, every listed company that they have to meet. These are the important points in the first chapter. The next chapter, FEMA, again, you can spend 1.5 hours there, right? Here, first important point is definition of resident in India, right? The residential status, that definition is very, very important. Person of Indian origin, definition, and restriction on dealing in foreign currency and foreign securities. Capital account transaction, current account transactions, those lists very important in capital account transaction as well as current account transactions. And acquisition and transfer of immovable property outside India, acquisition of transfer of immovable property in India by NRI, person of Indian origin, as well as non-residents. We had 3 different categories there. And export related procedure, the time limit for realization of proceeds, etc. that we have discussed. And adjudication and appeal provisions, again here the appellate authorities. Import related, ECB and ODI. ECB can be asked in MCQs, etc. So we may have to look into descriptive. I don't think so they'll ask. ODI is important. Overseas direct investment is important. The limits that we have to remember there. Then FCRA, Foreign Contribution Regulation Act, simple chapter, half an hour. Definition of foreign contribution and prohibition list, section 3, lists of prohibited cases, allowed cases, registration procedure, prior permission procedure, and power of central government to prohibit, restrict, etc. Then whatever foreign contribution we have received, utilization for administrative purpose, that limit, over and above the limit, what is the procedure to be followed, and adjudication and appeals. Again, in all these chapters, adjudication and appeals become important. Next, 4th chapter, arbitration and conciliation. It's a general topic, nothing much technical there, right? So 30 minutes we can easily cover these. What are there here? Requirement of arbitration agreement. There are certain points, right? For arbitration agreement, what are the requirements? Matters that can be referred to arbitration, matters that cannot be referred to arbitration. That is important. And proceedings, arbitration proceedings, types of award, those 4 types of awards, very, very important. Appeals, cost of arbitration, how will they apportion it? Then we have conciliation. What is conciliation? Matters that can be referred to conciliation, difference between conciliation and mediation, right? And proceedings, conciliation proceedings. Then PMLA, small topic, 45 minutes we can cover, but very important. Definition of money laundering, definition of proceeds of crime, property, scheduled offenses, and payment system. These definitions are important. We have to remember those definitions. Punishment for money laundering. What is the punishment that is there? It's 3 years to 7 years imprisonment. In case of drugs and narcotic, that act, it will be 10 years, right? Imprisonment. Then obligation of banks, financial institutions, intermediaries, they have some reporting obligations, suspicious transaction report, cash transaction report that they have to submit. Attachment related, provisional attachment, final attachment, the time limit for provisional attachment. Even during provisional attachment, they can enjoy the benefits of that property, etc. That points. Then adjudication and appeals, again in PMLA. Then the last chapter, Insolvency and Bankruptcy Code, IBC 2016. 1 hour, 30 minutes, 1.5 hours, very important chapter. Here, to start with, we have definition of corporate guarantor, financial and operational creditor, corporate debtor, right? These are the things that are required to for us to understand the next few provisions. Then registration of insolvency professional, initiation of CIRP, very important, the process. Who can make an application? Application by financial creditor, operational creditor, corporate debtor, different sections, different procedures involved, right? So look into those, specifically financial creditor and operational creditor, the difference in the application. Financial creditor, no demand notice to be sent, direct application, right? Upon default. So that those points. Then who cannot apply for initiation of CIRP? There are some lists. Time limit to complete. Extension can be given, one-time extension. Then moratorium order, what will be prohibited during that moratorium duration. Then interim resolution professional will be appointed. Committee of creditors will be constituted. Meetings of committee of creditors, what happens in the first meeting, resolution professional will be appointed. right? And for certain cases, prior committee of creditors approval is required. Major decisions, 66% approval, normal 50% approval, right? And information memorandum, then resolution plan will be submitted by many people. In that one resolution plan will be accepted, that will be sent for approval. If approved, go to NCLT for final approval, correct? If that doesn't go well, liquidation process, that is also given in IBC itself. In liquidation, preference transactions similar to fraudulent preference and are winding up, but time limit is different. Then order of priority, there are some changes in order of priority here when compared to winding up. These are CIRP and liquidation process. Then we have fast track CIRP. Who can go with fast track CIRP and what is the time limit? Apart from that, the process is the same as CIRP. Then PPIRP can be important because last exam was the first exam which was applicable, and one question was asked there. So one question can be asked in this exam also because this is recent amendment, right? PPIRP, those differences that we have discussed in the class is more than sufficient. Okay, to answer the question. Apart from that, normal CIRP process will apply subject to those restrictions, those differences. Then voluntary winding up, a simple process that is there in the material that we have to look into for voluntary winding up. Okay, now these are the chapters that are there, the topics that we have to cover in those chapters. After that, the day of the exam, if we get as a part of last minute revision, what we can do is specific revision of penalties in all chapters. In CAS material, at the end, you have the penalties, right? So just to go through those penalties, because yes, when we are discussing when we are revising the provisions, you would have gone through the penalties, but you might not remember all the penalties. So just to go through those penalties, resolutions required. Again, these are also specified in the summary part of every chapter in the CAPS material, correct? So those resolutions, where special resolution, where board meeting resolution is required. So you can revise those things specifically so that it becomes easy to remember. And limits, 186 has different limit, right? So specific audit committee requirement is different. Nomination Remuneration Committee, same as audit committee. Independent directors, audit committee, and nomination remuneration committee, same applicability. So these are some of the limits that we can focus on, that we can specifically revise. And RTP of May 22 and November 22, compulsorily have to go through. Compulsorily have to go through. Just turn the pages, it's okay, right? So certain questions, MCQ as well as descriptive, can be lifted from the RTP itself. So that would be easy for us. So if you can make half an hour time for going through those RTPs, that will definitely add value. And these are the things that we have to go look into on the day of the examination as part of last minute revision. Is that clear? Yes. So these are the specific points that we have to keep in mind, specific things that we have to focus on. With this, yes, we'll look into the conclusion part. Have positive attitude and mindset, right? Have that confidence and belief. Don't panic. Even if you're not remembering any question in the exams, nothing to worry. You have 30 MCQs. Okay, you can easily score 20 marks there. So nothing to panic and get. I'm telling 60, getting 60 is easy. So 40 is definitely possible. 40 is definitely possible. How much ever difficult the question paper is. So we need not panic. Even if you're not remembering, even if you go blank in the examination hall, nothing to worry. Relax for 5 minutes, drink some water. Then again, refresh yourselves, and again you can start with answering. You can afford to give 5 minutes for that because the paper will not be too lengthy. And at the end of the day, you have put in all your efforts till date, right? So you will definitely get through. Today, with having said that, I'll not give specific timetable or specific topics that you can cover today, tomorrow, and day after. You would have already planned. So whichever is comfortable, whichever is convenient to you, go with that, because at the end of the day, you should have that confidence. You should have that right mindset. So if you're following what you have planned, that gives you the confidence, that gives you that right approach, which is required for the exams, right? So you are the best person who can decide what you are learning, what you are revising today and tomorrow. Having said that, since today was auditing, cover some simple topics. Could be some of the topics in economic laws like arbitration, it could be PML, it could be FCRA, etc. Some easy topics in economic laws, or some miscellaneous topics in company law as well. Nidhi companies, dormant company, etc. Some simple topics we can cover so that tomorrow you can start with the standard topics, meetings of the board appointment of directors, etc. right? So cover some simple topics, easy topics today. And as I said, no specific timetable that I'll suggest. Okay, so with this, believe in yourselves, have confidence in yourselves. Definitely you can. Definitely you can. So you become what you believe. So if you believe you'll get above 60, definitely you will get it, right? And you are so close to the victory. It's a matter of 11 more days, right? So it's 11 more days, your exams will be done. So you're so close to the victory. Don't you dare give up. Yes, it will be difficult at some point. You might feel down at that point. Remember, it's just 11 more days that you have to put in your efforts. So push yourselves, put in additional efforts that is required for the next 11 days. Definitely you will get success. Okay, so everyone repeat after me. I can do this. With this, I'd like to conclude by wishing everyone all the very best. Right, you will achieve success. Definitely you can. Just keep yourselves calm. Focus on what you have to do in the next 1.5 days, rather what will happen on the examination day, right? So just focus on what you have to do in the next 1.5 days. Definitely it is possible. Have a plan. Have a plan on what all the topics that you have to cover for in the next 1.5 days, specifically session wise plan or hour wise plan, whatever is comfortable to you, so that you can easily cover those, you can implement that particular plan. Clear? Yes. Anyone has any specific point? Will not waste much time. You have very less time to prepare.
Sir, I require a clarification.
Yes, Konya.
If they have given 4 wrong answers for the question, what to do? Actually, I encountered one question today in auditing.
Okay.
None of the answer is matching. It is not verbatim from reading the clause. Also, answer is not matching.
At the end of the day, it's not that there should be a correct answer, perfect answer in the MCQs. They say choose the most appropriate answer, right? So the most appropriate out of the given options, which is the most appropriate option that we have to choose. Having said that, there can be a question which has completely irrelevant options also, which might not be correct. In that case, attempt that, you should get the grace mark. Anyhow, there is no negative marking.
In audit, one question came, sir. It's really a clause also they
will not discuss auditing. Forget auditing now.
No.
Yeah,
That only one, sir.
Yeah. Right then. Okay, we'll conclude the session. We'll not waste much time. All the very best, guys.
Thank you, sir.
Thank you very much, sir.